This is a Canadian court judgment, R versus Haynes, 1999. Can Lee, 18979. Article 85 of R versus Haynes. It is clear, therefore, that Section 24 is critical to carrying out the Charter's purpose of investing individuals. So you see, it's not person, it's not citizen, it's individuals. So it is clear, therefore, that Section 24 is critical to carrying out the Charter's purpose of investing individuals with the power to defend themselves. Okay, not a lawyer, not someone else, but yourself, to defend yourself against incursions on their guaranteed fundamental rights and freedoms. The process of entrenching them, which is the term frequently used to describe the Charter's purpose, entails giving a solid means of defending them to every individual. R versus Haynes, Section 101, bottom paragraph. The determination whether to enforce constitutionally protected rights under Section 24 was never intended to revert to the executive arm of the government. Indeed, as has already been discussed, a primary purpose of the Charter was to place courts between the executive and the individual, to protect the latter's, individuals' fundamental rights and freedoms. R versus Hape, 2007, SCC 26. R versus Hape. The Constitution Act has brought forth the rights and freedoms guaranteed and expressed in the Covenant in accordance with the provisions of the Covenant. Paragraph 53. It is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. The presumption of conformity is based on the rule of judicial policy that, as a matter of law, courts will strive to avoid constructions of domestic law pursuant to which the state would be in violation of its international obligations. International Covenant on Economic, Social, and Cultural Rights, Article 6, the states, parties to the present covenant recognize the obligation to work. The right to work, which includes the right of everyone to the opportunity to gain his living by work which he freely chooses or accepts, and will take appropriate steps to safeguard this right. The steps to be taken by a state party to the present covenant to achieve the full realization of this right shall include technical and vocational guidance and training. In the last video that I made, we were looking at the right to work. So we were looking at the International Covenant on Economic, Social, and Cultural Rights, Article 6. And it stated that everyone had the right to work. Now, it also stated that in order to safeguard this right to work, the state parties would have to take the appropriate steps. And then they named or enumerated the steps that would be taken. And they said that the state parties would have to produce technical and vocational education or training. So in order to preserve an individual's right to work, the state party had to produce technical and vocational education. The way this right would play out, if we actually look at it, the way it's supposed to be expressed, would be that, remember, us as human beings, we have the choice. It's a right. Are we going to use it or not? If we choose to use the right to work in order to gain our own living, then we would need the qualifications in order to be able to work. We would need the technical and vocational studies or education. However, if we choose not to use the right to pursue, earn, or gain a living, then there would never be a need for a human being to be subjected to the technical and vocational education that is being promoted by the government. Do you see how that works? Just one more time. So as human beings, we have a right to decide if we're going to use our capacity to work in order to gain a living and earn a living. This is a right we've been given. Now, if we decide to use that right, we need technical and vocational training to go out there in the world. Am I going to be a police officer? Am I going to be a doctor? Am I going to be a lawyer? Am I going to be a plumber? We would learn that through our education, our technical and vocational training. But long before we should have ever been submitted to any of this, we should have been taught our right as human beings to decide, will you pursue, earn and gain a living, or will you enjoy a living? That's your choice. And by presenting us this choice, this option, if some of us would have decided, no, we wish not to pursue, earn or gain after a living, we don't want to follow after mammon and follow after money, then we, individuals, would have never been subjected to any of this side that we've all been subjected to right now. The International Covenant on Economic, Social, and Cultural Rights, Article 13. This states, parties to the present covenant recognize the right of everyone to education. They agree that education shall be directed to the full development of the human personality and the sense of its dignity, and shall strengthen the respect for human rights and fundamental freedoms. They further agree that education shall enable all persons to participate effectively in a free society. The states, parties to the present covenant, recognize that with a view to achieving the full realization of this right, primary education shall be compulsory and available free to all. Looking into the International Covenant on Economic, Social, and Cultural Rights, Article 13. This is where it brings forth education, the rights and obligations concerning education. We find the following. It states that education, first and foremost, shall be for the promotion of human rights and freedoms. That's what education was supposed to be geared at. And then secondarily, it says they further agree that education shall be for persons and their ability to participate in a free society. Now, when they talk about education, they say that education, primary education, shall be compulsory. It's an obligation. And then they go on and they further talk about secondary education. Now, they no longer state that this secondary education is compulsory. You don't find that statement in there. Neither will you find it when they speak about higher education. It is not compulsory. It is not an obligation. Primary education is, secondary is not. But the definition, the terms that they give, describing what secondary education is they say including technical and vocational training. So remember, we just looked back at the right to work, and the state party had to secure this right to work, if we choose to use it, through technical and vocational training. And here we're seeing that this technical and vocational training, secondary education, high school, look at it like that, this secondary education is not compulsory, no obligation. And it was meant to teach the person how to operate in a free society. Because we look at the description of it, the technical and vocational training, and we join it into Article 6 of the International Covenant that says the state parties to secure the right must secure technical and vocational training, and here it's coming out. As an adult, I know at this point we're not adults, we're 16 to 18, but let's just play it out. As an adult, we don't have to choose to pursue or earn or gain a living. And therefore we wouldn't have to subject ourselves, like I was saying before, to any of this. But when we're minors, we're young, they were saying, international law was saying that this is compulsory, the education we're going to give you, and it should have been to the promotion of human rights and freedoms. Grade 1 to 6, let's say. Should have been for the promotion of human rights and fundamental freedoms for us to learn and understand international law and domestic law and how we fit into it as an individual and what are our rights and freedoms. That was the obligation. And then secondarily to that, it was to include technical and vocational training. Now that would fall on who? On the one who had chosen to work. And when you go out and choose to earn or gain a living, you change your capacity from that of human being to that of the artificial person. Now, primary education, secondary education, even if you choose to use the right to work, secondary education and higher education was supposed to be free. The way they word this, they say primary education, free. They just state it, free, no problem. And then they say higher education and secondary education will be progressively free over time. But nevertheless, they have to make it to be free. This covenant and the obligations came to alive, if you will, in 1976, March 1976. So that's many, many decades later. And still, they're charging for not only secondary education and higher education, they're also charging for primary education, grade 1s to 6. They say you got to pay for school books, you got to pay for such and such things. All of this was supposed to be free. And the government didn't fulfill their obligations. Now, in order to see what's transpiring with their obligation, let us look into domestic law and see what exactly did the government do. Did they outrightly just ignore their obligation, or is there some other mechanism, some other operation of law that the government of Canada is using in order to shake off their obligation? The Education Administration Act. Her Majesty, by and with the advice and consent of the Legislative Assembly of Ontario, British Columbia, Alberta, Manitoba, etc., enacts as follows. Minister means the member of the Executive Council charged by the Lieutenant Governor in council with the administration of this Act. The Executive Government Organization Enactment. Members of the Executive Council. There shall be an Executive Council of the province, which shall be composed of such persons as the Lieutenant Governor appoints. Order of rank of ministers. The members of the Executive Council shall be ministers of the Crown. The International Covenants in Article 2.2 state that all the rights and freedoms that are brought forth in the covenants must be expressed in domestic law. The other video we saw how the right to vote was recognized in international law and subsequently transferred into domestic law. Now here we see that there's a right to education, and since we understand now about international law and the obligations upon the state party, we have to find the expression of this right to education in domestic law. Now, this obligation in Article 2.2, where you must express these rights and freedoms, they fall upon the executive government. They fall upon the ministers of the Crown. They fall upon the legislators of this government, the ones who are making up the laws. Well, not actually making up the laws, but writing up the laws. And most definitely, they fall upon the sovereign of this territory, Her Majesty. That's where the obligations lie. So let's see how they fulfilled the right to education in domestic law. When you look into the Education Act, this is all the same across the provinces. It all has the same operation of law present within each enactment. Now, there's a minister that is in charge of the act. That's what you'll find. It states this. And that this minister who's in charge of the act was appointed to his position by the Lieutenant Governor. Now remember, when we look into the Constitution Act of Canada, through Article 8, 9, and 10, it talks about that Her Majesty, Queen Elizabeth, is the executive power here in Canada, and that she transfers these powers, her powers, to the Governor General of Canada, and the Governor General subsequently transfers these powers to the Lieutenant Governor. But they're all representatives of the Queen. They're all operating her power and on behalf of Her Majesty. That's what it states in the Constitution Act of Canada 1867. Now here we have the Minister of Education appointed by the Lieutenant Governor, who's operating on behalf of Her Majesty. And it says that this Minister of Education is the member of the Executive Council of the province. So if you're in Ontario, the Minister of Education is a member of the Executive Council. If you're in Manitoba, then the Minister of Education is also a Minister of the Executive Council, a member of the Executive Council. Now when you look, the Executive Councils, the members of the Executive Councils are ministers of the Crown. It clearly states that. And as ministers of the Crown, they have obligations to the international covenants. So they are executive powers, and they have obligations to the international covenants. Once again, let's quickly walk through it. The Education Act is produced because international covenant says you must produce education on your territory. They put a minister in charge of the Education Act. It's the Lieutenant Governor who appoints the minister. Now this minister is also a member of the Executive Council, and as such he is a minister of the Crown. And subsequently he has obligations to the international covenants to respect the rights and freedoms that have been enumerated and listed in the covenants concerning education. And let's see if he does. The Education Administration Act, Supervision of Schools, Article 2. The Minister is responsible for the supervision, control, and direction of all public schools and of all other schools established pursuant to this Act. The Education Administration Act, Article 3, Powers of the Minister. The Minister is responsible for establish and operate or provide for the establishment and operation of technical, vocational, agricultural, summer, residential, or any other schools. Approve course studies, including correspondence and other courses. Establish courses of study, including setting the amount of the instruction time, and authorize programs and instructional materials. Approve textbooks to be used and arrange for the printing and publishing of textbooks or other instructional materials. In the Education Act, we find the following. The minister, who is the minister of the Crown, is responsible. That's what it states, these enactments. So, it's a duty, it's an obligation. He is responsible for the supervision, control, and direction of the schools in Canada or in your province. Now right there, that produces the liability for us. Minister of the Crown, you're responsible. You're responsible to international law. You're responsible to my fundamental rights and freedoms concerning education. Now, it says the minister is responsible to approve course studies, authorize programs, including instructional materials, and approve textbooks. So it's the minister who does all this, the minister of the Crown. Now, when we looked into international law, it taught us that first and foremost, education was supposed to be geared to the promotion, the teaching of fundamental human rights and freedoms, and secondarily to the promotion of vocational and technical training for a person who is going to work. That was the purpose of education. However, when we look into these schools that the governments have produced, such as police training or plumber training, no matter what it is these schools have produced, when we look into the instructional materials, we do not find them fulfilling their obligations concerning human rights and fundamental freedoms. In fact, if you look into the police services enactment across Canada, you will find, well, especially in Manitoba, you will find that it is stated that the police are under obligation to respect the rights and freedoms that are brought forth in the Charter and that this obligation is recognized by all that are in law force. Yet when you come into the police training that they are given, and you do a research, because I have, into the manuals and into the approved textbooks and into the instructional materials that the minister is providing for them, they are failing miserably on teaching them what our fundamental rights and freedoms are. Yet they're saying, here in your enactment, which governs your duties, police officers, you have the obligation to respect them, but yet in the training, it was never provided for them. So what we learn from the enactment is that the enactment teaches us that the minister is responsible for the materials, for the courses, and for the instructions that we are receiving. So if there was a lack of instructions on their behalf, then they are liable, and the liability is there. Now remember, education was supposed to be free. Now let's see what the enactment says about free education. The Education Administration Act, Article 4, Regulations, for the purpose of carrying out the provisions of this Act, according to their intent, the minister may. You see that? It doesn't say must, it says may. The minister may make such regulations and orders, now, governing the operation of technical, vocational, agricultural, summer, residential, and other schools, and designating the qualification of persons, notice that now, to be admitted as pupils therein, and the fees and charges, if any, to be paid by the pupils. The Interpretation Act of Canada, the interpretation of shall and may. In Article 11 of this Act, it states, the expression shall is to be construed as imperative or an obligation, and the expression may as permissive. It doesn't create an obligation. So we're looking into the enactment, and it states that the ministers, they may charge pupils. Couple of things here. First of all, notice the designation of human being is long gone. It's now pupils, and it went from human being to persons to pupils. If that's one thing that I've been trying to stress throughout the couple of years that I've been making my video, is that law always wants to remove your designation of human being with the fundamental rights and freedoms and designate you or classify you any other designation or any other title, such as pupil or worker and so forth, not human being. But the minister may charge. Now, may does not produce an obligation. In the Interpretation Act of Canada, when you look at the word may, it's permissive. You can do it, but you're not obligated to do it. Now, the minister may charge pupils for technical and vocational education. Now remember, we looked at the right to work, and the right to work is a choice, and the state party must secure that right with technical and vocational education. And we saw, furthermore, in international law, that secondary education was supposed to be for technical and vocational education. Now here it says the minister may charge for this type of education, but it doesn't say he has to charge. The enactment doesn't bring forth the obligation. So therefore, it doesn't break international law, the enactment itself. If the enactment said, for example, the enactment says you will charge such and such to pupils who are being educated in such and such ways, then the enactment would be breaking the international law, and the legislators would be against international law. But here, that's not what's transpired. What's transpired is the minister, who is a minister of the crown, who has that international obligation, he is the one that has broken international law, because it's the minister who charges, and he's not obligated to charge. The enactment says you may charge, but we're not forcing you. There's no obligation. It's not a duty. But however, the minister then subsequently does charge, and then he breaks, or the office has broken international law. So from grade 1 to 6, if you're charged for textbooks, lunch fees, whatever fees it may be, then it's the minister that has made this through regulation, and he is guilty now of breaking international law. if you've gone to high school, college, or even university, and you've paid for this education, this vocational and technical training, well, the minister charged you and he broke international law. Remember, it was supposed to be progressively free. It's been close to 4 decades. That's plenty of time for Canada to have implemented the free education. And anyone who understands their right, as I spoke about in the beginning of this video, can go before the courts and say they haven't fulfilled their obligations. I want a remedy because of what is transpiring with the executive power. Here, the executive power, the Minister of the Crown, is not obligated but can charge you for education, and he decides to charge you for education, which goes against international law. And it should show you that they exactly know what they're doing. Because once again, if the enactment would have created the duty or the obligation itself, then the enactment would break international law. But since the enactment didn't break international law, but the office of the minister does, it's up to the individual, that one individual, to understand all this and then to go forth and say, you owe me back the money that I paid. First of all, you never explained to me that work was an option, it was a choice, and you forced me into working, and then I had to take vocational and technical training, and I paid for it with my own money, when the obligation was that you should have been paying for it, to preserve that right. The International Covenant on Economic, Social, and Cultural Rights, and you'll find the same statement in the International Covenant on Civil and Political Rights. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. Canley, reference RESS 193 and 195.1 of the Criminal Code, Mann, 1990, 1 SR 1123, 1990, Canley. It is important to note that the onus or the responsibility is on the person bringing the challenge to demonstrate not only the restriction of the rights, but also that the state has not abided by the principles of fundamental justice. So when we look back into the covenant now, in Article 5, it talks about the fact that no person has the right to take any actions that are aimed at any of the destructions of these rights and freedoms. And it goes on to state that, you see, the governing factor, as I've been continually stating here in my videos, are the international covenants. This is the fundamental principle of justice. People have a little bit difficulty understanding what is the principle of fundamental justice. The principle of fundamental justice is what the covenant states. When you read through the covenants, you will see that it says that in no case may a people be deprived of such and such. And this right cannot be limited in no case, in no way. And then in another time it'll say this right can be limited in such and such fashion. This right can be limited in such and such fashion. This other right cannot be limited. That's the principle of fundamental justice. And that's what the State Party Canada has to build off of. You further look into the Emergencies Act, and the Governor and Council is aware, or the Executive Council is aware of the fact that they must have respect for the International Covenant on Civil and Political Rights. Even in the time of emergency, there are rights and freedoms that can never be abridged, never be limited. So that should be showing you there are rights and freedoms that can never be abridged and never be limited. So even if you're worried about something that's called a principle of fundamental justice, that principle can never touch these fundamental rights and freedoms, because they're never to be abridged or limited, even during an emergency. But what's actually transpiring is that some of you are confused about what the principle of fundamental justice is. You've listened to other individuals who have told you what the meaning of this terminology is. And what I'm trying to share with you tonight is that when you use the word principle of fundamental justice, or the term principle of fundamental justice, what you are actually saying is that it's a principle, an operation of law, a mechanism that is used in which the covenants allow a state party to limit certain rights and freedoms. So you have to go into the covenants now and you have to take each freedom, each right individually and look at them and see, does the covenant allow the state party to limit this right, or does the covenant not allow the state party to limit its right? And then if you find that the covenant does allow the state party to limit this right, come back into domestic law and see exactly how the state party has limited that right. Now, above all this, Article 26 of the Constitution Act of Canada, 1982, trumps anything that the executive powers here in Canada can do. Even if you want to worry about the fact that some of the constitutional rights can be limited, can be abridged, it doesn't matter, because you don't need to stand on the Constitution itself. Through Article 26 of the Constitution Act of Canada, it allows you to go directly into the International Bill on Human Rights. It's like your checkmate against the state party. So if the state party, for whatever reason, decides to limit your rights and freedoms, you have the ability to go through Article 26 here in Canada, specifically. I'm not talking about other countries, because your Constitution Act doesn't have the equivalent article of law that we have here. So it's a safeguard to our rights. So stop worrying about the fact that can they apply a principle of fundamental justice against me to strip me of my right, and worry more about, okay, the executive powers have removed my right, they've disrespected their obligation and their liability to international law, and now I see through jurisprudence that I must go forth into a court of law and have my remedy produced on my behalf. Now, before you can ever get into a court of law to have your remedy produced on your behalf, there are quite a few steps that has to be taken. First and foremost, the most important step that any individual needs to take is to bring forth a claim of recognition, a claim of understanding, bringing forth to the executive powers in this state party, Canada, that you understand what has transpired against you in law, that you know that your designation has been changed, and that you understand that you have fundamental rights and freedoms that have been protected internationally and have been protected domestically. Only up till now you have never been taught them, you have never been exposed to them, or they have not been explained to you. That would be your first step. Now, it's important, again, and I'll say it over and over and over again, when you make a claim, any type of claim, you have to be able, first of all, to back that claim up with an article of law, and that claim must produce a liability or an obligation against the other party. So if you draw up or bring forth a claim of recognition and you claim a whole bunch of things that are not liable upon Canada, they have no obligation to you. And when and if you ever go into a court of law, the judge will laugh at you and say, why are you claiming this? What makes you think that there's an obligation upon the executive powers to do such actions on your behalf? But and if your claim is built properly through the international covenants, through domestic law, pinpointing, like we did tonight with this Education Act, pinpointing the removal of the right and the obligation that Canada had, how they're disobeying international law, then you can have a remedy produced on your behalf. So the first step for anybody is to take time and to get a claim of recognition. Either create one or learn about it and study it. Not only that, by doing a claim of recognition, it helps you to get more familiar with the laws, international laws, domestic laws, and their operation thereof. Secondly, you're going to have to learn how to use the justice system, which is not very difficult. If you're operating from the capacity as a person and going in there under the rules of court and under their enactments and regulations, then yes, it gets very expensive if you're with a lawyer, and can get very tedious even if you're trying to do it yourself. However, from the beginning of this, you're not operating under that capacity. You're operating under the capacity of a human being. And the court's primary or essential reason that they're there or are in existence is to protect fundamental human rights and freedoms. And they know it. But again, we've just never been taught it. And I'm going to go over a few jurisprudence, a few court judgments in the coming days concerning what the courts know and what is our obligation before them. I shared with you a little bit in the beginning of this video how the courts are saying that it's up to you, the individual. The onus, the responsibility is upon you to bring forth the problem, first of all, to the court, and to demonstrate to the court exactly what has transpired. Pinpoint the removal of the freedom. Pinpoint the removal or denial of the right and freedom. And then the courts will honor you. But the onus is on you. And it is said, or it is written in law, that the responsibility to protect my individual fundamental rights and freedoms lies upon my shoulder. That no one else can do it for me. Only me, as a one human being, can understand, stand up, and protect my own right. I can share rights and freedoms with others. I can teach others rights and freedoms, but only they can stand up and exercise their rights. And as you saw in the jurisprudence again, the judges are aware of this. They know it. We've been vested, we have the power to enforce these rights against the executive government, but all this knowledge is being hidden. I hope you enjoyed this video, and another one will be coming in a few days. Take care.